Welcome to our video on the topic of judge-made law and the declaratory theory of law. This is Victoria, and I will explore the concept of judge-made law and its relationship with the declaratory theory of law, as well as its application in the legal system. So let's dive right in. To understand judge-made law, we need to discuss the declaratory theory of law, as proposed by the renowned legal scholar William Blackstone. According to Blackstone, judges do not create law, but rather discover and declare pre-existing legal principles. Blackstone's declaratory theory emphasized that judges' role is to interpret and apply existing laws rather than engage in law-making. This theory is rooted in the idea of stability, predictability, and the rule of law, as it suggests that judges should adhere to established legal principles when making decisions. Another important concept to consider is the separation of powers. Under this principle, the authority is divided among the executive, legislative, and the judicial branches of government. In a strict application of separation of powers, judges are seen as declarers of the law rather than law creators. Judges, under this strict interpretation, play a crucial role in applying the law. They analyze the facts presented in a case and interpret the relevant legal principles. Their primary responsibility is to ensure that justice is served by impartially applying the law, without encroaching upon the legislative branch's authority to create laws. However, in certain situations, judges may encounter legal issues that are not explicitly addressed by existing statutes or precedents. This is where the concept of judge-made law comes into play. Judge-made law, also known as common law, arises when a judge is faced by a legal question that requires the development of a new legal principle. In such cases, judges analyze the facts, interpret the law, and make decisions that establish new precedents. These decisions become part of the legal system and serve as precedents for future cases with similar circumstances. This doctrine, known as stare decisis, ensures consistency and predictability in the application of the law. It is important to note that while judge-made law plays a significant role in filling gaps in the law, critics argue that it encroaches on the legislative branch's authority. They believe that judges should restrict themselves to interpreting and applying existing laws rather than shaping legal principles through their decisions. One notable case that highlights the debate surrounding judge-made law is Kleinwood-Benson against Lincoln. In this case, the court had to determine whether a statement of law made by the House of Lords in a previous case was binding or merely persuasive. The court held that the statement was not binding as it was considered obiter dictum, a statement made in passing and did not form part of the binding legal principle of the earlier decision. This ruling exemplified the court's adherence to the declaratory theory of law and its commitment to the principle that judges should not create binding laws through their statements.
Next, I'll be talking about factors that lead to the development of judge-made law. Lord Reed, who was a dominant figure in the House of Lords in the 1960s and 1970s, acknowledged the role of judge as a lawmaker in a famous address which he presented to the Society of Teachers of Public Law in 1972. He dismissed the idea of judge, only declared the law as a fairy tale. Judge-made law when the law is unsuitable to apply anymore, or in other words, the law is outdated. In R. against Clark, 1949, a husband was charged with rape upon his wife in circumstances where the justice had made an order providing that the wife should no longer be bound to cohabit with her husband. Judge Byron refers to quash the charge. He accepted Hale's proposition as generally sound, but said that the position, therefore, was that the wife, by process of law, namely by marriage, had given her consent to her husband to exercise the marital right, but by the further process of law, namely the justice's order, her consent to marital intercourse was revoked. Thus, in my opinion, the husband was not entitled to have intercourse with her without her consent. As further illustrated in R&R Marital Rape Exemption 1999, the defendant married his wife, but after the marriage did not work, she moved out to live with her parents. They were separated but not legally divorced. The defendant broke into her parents' home and attempted to have sexual intercourse with the plaintiff, who did not consent. The defendant was charged with attempted rape and with assault occasioning actual bodily harm. The court upheld his conviction for attempted rape. The concept of irrecoverable consent of a wife to her husband was classed as an unacceptable concept in modern times. Each is seen as equal partners in marriage. Sir Matthew Hill, in his History of Pleas of the Crown, wrote, "But the husband cannot be guilty of rape committed by himself upon his lawful wife, for where there are mutual matrimonial consent and contract with the wife hath given herself up in this kind unto her husband, which she cannot retract." The common law is, however, capable of evolving in the light of changing social, economic, and cultural developments. Health proposition reflected the state of affairs in this respect at the time it was enunciated. In modern times, as any reasonable person must regard that conception as quite unacceptable. Since then, the status of women, and particularly married women, has changed out of all recognition in various ways, which are very familiar. Things that were applicable at the time were not applicable anymore after 250 years. Towards the end of the judgment, Lord Lane said, "The remaining and no less difficult question is whether, despite that view, this is an area where the court should step aside to leave the matters to the parliamentary process. This is not the creation of a new offence, it is the removal of a common law fiction which has become anachronistic and offensive, and we consider that it is out of our duty, having reached that conclusion, to act upon it." Judge-made law also steps in when there is a need to create new recognition of rights of the individuals. As illustrated in the case of Donahue against Stevenson, Miss Donahue went to a cafe with a friend who bought her an ice cream and a bottle of ginger beer. The ginger beer water, which was dark and opaque, contained a decomposed nail. Miss Donahue claimed after she had consumed the most of the ginger beer, she saw the remains of the badly decomposed nail float out of the water that was being poured into her glass. In the following days, she became ill and upon seeking treatment, was diagnosed with severe gastroenteritis and shock. She took legal action against the ginger beer manufacturer. Her chances of success seemed limited. She could not sue Stevenson for breach of contract, as she herself did not purchase the drink. It was also unlikely she could prove Stevenson had sold a dangerous product or knew that his product were defective. Instead, she claimed Stevenson owed a duty to his consumer to take reasonable care to ensure his product was safe for human consumption. In the House of Law, Lord Aitken arose to deliver a judgment that would have a lasting impact on society. His decision established that a manufacturer of a product owed consumer a duty of care. In his judgment, it stated that a manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate consumer in the form in which they left him with no reasonable possibility of intermediate examination, and with his knowledge that the absence of reasonable care in the preparation or putting up the product will result in an injury to the consumer's life or property, also duty to the consumer to take a reasonable care. Also, it established the general principle of duty of care concept in law. The test was formulated by Lord Aitken and is generally referred to as the neighbour test or neighbour principle. As cited, you must take reasonable care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be a person who are so closely and directly affected by my act that I ought reasonably to have them. With that, I'll pass the presentation to Cindy.
I'm going to continue talking about how judges can make laws by adapting to social change. First of all, Lord Denning in the lecture called the need for a new equity argued that judges had become too timid about adapting the law to the changing conditions of society. They were, he felt, leaving this role too much to Parliament, which was too slow and cumbersome to do the job well. In the tort law case of McLaughlin against O'Brien 1983, the claimant in this case suffered mental illness after a car crash in which her husband and 3 children were seriously injured. 1 child died. The news of the accident was communicated to her by a friend. When she went to the hospital, she witnessed their injuries and suffered severe shocks, leading to depression. It was held that the claimant's claim for psychiatric injury was allowed. The claimant's psychiatric injury was reasonably foreseeable. She had close ties with the victim, and the shock was caused by sight and hearing of the immediate aftermath of the accident. The ratio in this case is that it laid down the criteria for negligent liability towards secondary victims of psychiatric shock. Lord Wilberforce states that reasonable foreseeability alone is not enough to establish liability towards secondary victims. These further 3 elements need to be considered, namely the cause of person, the proximity of such person to the accident in both time time and space, and the shot must come through sight or hearing of the event of its immediate aftermath. Lord's government stated in Orator that the cause function is to adjudicate according to principle, and if the results are socially unacceptable, Parliament can legislate to overrule them. He felt that the risk was not that case law might develop too far, but that it stood still and did not therefore adapt to the changing needs of the society. Besides, a case where the judges did eventually show themselves willing to change the law in the light of social change is Fitzpatrick's against Sterling Housing Association 1999. This case concerned a homosexual man, Mr. Fitzpatrick, who had lived with his partner, Mr. Thompson, for 18 years, nursing and caring for him after Mr. Thompson suffered an accident which caused irreversible brain damage and severe paralysis. Mr. Thompson was the tenant of the flat. After the tenant's death, he sought a statutory tenancy as the spouse of the deceased. He sought a declaration that he had succeeded to the tenancy under the Rent Act 1977 as amended. He claimed that he was a spouse of the deceased in that he had been living with Mr. Thompson as his or her wife or husband, or alternative, that he was a member of Mr. Thompson's family. Lord Justice Ward concluded that the appellant succeeded as a spouse of, but if not, then as a member of the family of the original tenant. However, the meaning of member of a family could include a same-sex partner who had been involved in an established monogamous relationship. Such a person could not be a spouse within the meaning of the Act, but the family provision was more widely framed and allowed the court to take account of changes in society. Thus, a same-sex partner could take a succession of a property from that partner on death on the basis of being his or a member of the family. Lord Nichols of Birkenhead asked, can the expression family legitimately be interpreted in 1999 as having a different and wider meaning than when it was first enacted in 1920? He answered yes. A statement must necessarily be interpreted having regard to the circumstances when it was enacted. It is a fair presumption that Parliament's intention was directed to that state of affairs. When circumstances change, a court has to consider whether they fall within the parliamentary intention. They may do so if there can be detected a clear purpose in the legislation which can only be fulfilled if an extension is made. Furthermore, the court may substitute a reasonable meaning in light of the law as a whole, which is to apply the golden rule, if the literal rule generates an absurd result that Parliament could not have intended. In view of the same, the grammatical meaning of such words is usually modified by the judge to avoid the absurd outcome. In Howe against Ireland 1872, the defendant was charged with the offences of bigamy under Section 57 of the Offences Against the Person Act 1861. In this section, it stated that whosoever being married shall marry any other person during the life of the former husband or wife shall be guilty of bigamy. It was argued that following the literal rule would render legislation meaningless because it was impossible for someone who was already married to marry someone else. They might go through a marriage ceremony, but they would not actually be married. The court then used the golden rule to decide that the phrase shall marry should be understood to imply shall go through a marriage ceremony. Besides, in the case of Adler against Judge 1964, the defendant was charged under Section 3 of the Official Secrets Act 1920 with obstructing a member of the armed force in the vicinity of any prohibited place. He argued that the natural meaning of in the vicinity of mean near to, whereas the obstruction had actually occurred in the prohibited place itself, an Air Force station. If the literal rule was applied, the defendant did not infringe the terms of the Act as he was in the area instead of in the vicinity of the prohibited place. It was held that the defendant's conviction was upheld under the golden rule. The golden rule was applied to extend the meaning of Section 3. In the vicinity must be construed as in or in the vicinity of. Lord Parker stated Russia in this case that it would be extraordinary, I venture to think it would be absurd if an indictable offence was thereby created when the obstruction took place outside of the precinct of the station, albeit in the vicinity, and no offence at all was created if the obstruction occurred on the station itself. Clearly, the golden rule can assist the courts implement what Parliament actually intends and prevent the absurdity and injustice brought on by the literal rule. Next, I'll be passing it to Charmaine to talk about more practical guidance on judge-made law.
I'm Charmaine, and now I'll be presenting on how judges can give more practical guidance on how to advise in real-life situations as compared to a statute, which is general and vague in wording. As judges are not elected, they have the freedom to take unpopular stances when they are required to protect individual rights. This can be seen in the case Liversidge and Anderson. In 1939, the Home Secretary, Sir John Anderson, was permitted to interrogate people if he had reasonable cause to believe that they had hostile associations. This was permitted by Regulation 18B of the Defense General Regulations 1939, paragraph clause 1, which states, if the Secretary of State has reasonable cause to believe any person to be hostile origin or associations or to have been recently concerned in acts prejudicial to the public safety or the defense of the realm, or in the preparation or instigation of such acts, and that by reason thereof it is necessary to exercise control over him, he may make an order against that person directing that he be detained. The Home Secretary is part of the legislative and answer to the Parliament, but he is given executive powers to interrogate people. It is not fair to give so much power to the Home Secretary. In this case, Anderson detained Robert Liversidge, placing him in prison with no reason why. The question asked was the court permitted to evaluate the Home Secretary's action on an objective standard, comparing them to that which might be taken by a reasonable man. Would any other person behave the same way, or were they to measure the actions against the Secretary's personal standard? The majority of the House of Lords held that legislation should be interpreted to give effect to what Parliament intended, even if that meant adding to the words to give that effect. If Anderson acted in good faith, then he did not need to disclose the basis for his decision. Lord Atkins' famous dissent stated that majority will be more executive-minded than the executive, and had abdicated their responsibility as a court to ensure the executive did not overstep the boundaries. Lord Atkins said that the majority of the House of Lords was not thinking about how this judgment would affect the people. In this case, you can clearly see that judges are given freedom in stating dissenting stances just to protect the rights of the people. Judges should be uninfluenced by political or career considerations. I will also be referring to another case, which is A and others against Secretary of State for the Home Department. The case concerned the indefinite detention of the foreign prisoners in the United Kingdom prison, Belmarsh. The prisoners were held without trial under Section 23 of the Anti-Terrorism, Crime and Security Act 2001. This decision and subsequent detentions were challenged at the court in terms of their compatibility with the aims of the European Convention on Human Rights. The original case was brought by 9 individuals who were threatened with deportation without trial on the basis that there was some evidence that the individuals posed a national security threat. The 9 challenged this deportation decision of the Special Immigration Appeals Commission. All 9 were later detained under the Anti-Terrorism, Crime and Security Act 2001 pending deportation. Section 4 of this act enabled the individuals to be held indefinitely without trial or deportation. The House of Lords held that the provisions under which detainees were being held at Belmarsh Prison under Section 23 were incompatible with the Article 5 of the European Convention of Human Rights. It is stated in Article 5 Clause 1, which guarantees the fundamental human right of personal freedom. Everyone has the right to liberty and security of person. However, the Home Secretary was not required to release the prisoners. The provision had the effect of discriminating between foreign nationals and nationals of the state. As a result of the Lord's finding, they made a declaration of incompatibility under Section 4 of the Human Rights Act 1998. So, it is said by Lord Nicholas of Birkenhead, the duty of the court is to check that legislation and ministerial decisions do not overlook the human rights of persons adversely affected. This declaration of incompatibility does not affect the validity, operation, or enforcement of the law. Instead, Parliament must decide whether it wishes to amend the law. Also stated by Lord Bingham, the more purely political in a broad or narrow sense the question is, the more appropriate it will be for political resolution and the less likely it is to be an appropriate matter for judicial decisions. The smaller, therefore, will be the potential role of the court. It is the function of political and not judicial bodies to resolve political questions. Conversely, the greater the legal content of any issue, the greater the potential role of the court. Because under our constitution and subject to the sovereign power of Parliament, it is the function of the courts and not the political bodies to resolve legal questions. So, the outcome of this case is, with the pressure of the courts, the provision was then replaced by Terrorism Act 2005, which put in place derogation orders, also known as control order. It is an order made by the Home Secretary of the United Kingdom to restrict an individual's liberty for the purpose of protecting members of the public from a risk for terrorism. Its definition and power were provided by the Parliament in the Prevention of Terrorism Act 2005. The case decision is so groundbreaking because it shows a willingness of the judiciary to check the powers and exercise of the executive in matters concerning national security. Next, I'll be passing the presentation to Elise.
I will continue on with the topic judge do not have the ultimate power to make law. It is essential to acknowledge the limitations that constrain the authority of judges in shaping legal principles within judgment law. When it comes to law innovations, courts tend to defer to the Parliament, We must not overlook a crucial aspect. Parliament sovereignty stands as a fundamental principle within the UK Constitution, granting them supreme legal authority. It empowers Parliament to enact or repeal legislation without being subject to be override by courts. Judges openly acknowledge the necessity of common law development as well as understand their job is not to act as legislator. In the case of C against Director of Public Prosecution 1996, where the House of Lords was asked to consider a potential change in the law regarding children's criminal liability. The House of Lords refused to overrule the previous law, which established the rebuttable presumption in common law that children between ages 10 to 14 were incapable of committing a crime unless the prosecution could prove otherwise. Appellant was a 12-year-old boy who was seen by a police holding onto a motorcycle while another boy was trying to unlock the chain and padlock. He was then charged for interfering with committing a motorcycle theft, contrary to Section 9, Clause 1 of Criminal Attempts Act 1981. The law presumed him to be duly incapacitated, which refers to the presumption in law that a child is incapable of forming the criminal intent to commit an offence. However, based on the established facts, it was inferred that the appellant was aware that his action was seriously wrong and found sufficient evidence to rebut the presumption due to his age and proceeded to convict him. The issues of this case was whether at the age and mental capacity of an individual should be taken into account when determining criminal liability. A case referred to was Abbott against the Queen 1977, where Lord Salmon expressed the view that any significant policy changes in the law should be made by Parliament rather than the court. While judges have a responsibility to adapt and develop the principles of common law, they should not intrude upon the roles and responsibilities of Parliament. This fundamental legal doctrine has been accepted for centuries without question. House of Lords emphasized the need for judges to exercise prudence while altering the law in areas where Parliament had already thoroughly considered the same issues and declined to act. But in the case of R against Ministry of Justice 2014, Tony Nicholson, suffering from neurological disorder and intends to commit suicide but failed to do so as he was disabled and required a third party to actively assist him in ending his life. Appellant argued that those who assisted them in bringing their life should not face criminal consequences. He argued that laws concerning voluntary euthanasia or assisted suicide goes against individuals' right to make decisions about their own life and death. Therefore, claimed that Section 2, Clause 1 of Suicide Act 1961 was incompatible with Article 8 of the European Convention on Human Rights. Lord Justice Towson stated that fulfilling Nicholson's appeals would require a substantial legal reform. Courts referring to Section 4 of the Human Rights Act 1998, Parliament had delegated authority to courts to declare the incompatibility of legislation even if the decision fell within the sage margin of appreciation. According to Section 6, Clause 1 of the Human Rights Act, it is unlawful for a public authority, including the courts, to act in a manner that conflicts with a right protected by the ECHR. Since courts are responsible for ensuring that their interpretation of the law align with the principles of the Convention, Section 6, Clause 2 provides an exception when a court is obligated by primary legislation, even if it results in an outcome incompatible with Convention right. These exceptions uphold parliamentary sovereignty. However, Section 4 of the Act allows the court to declare that legislation is incompatible with a convention right. This mechanism allows the court to draw attention to the discrepancy between legislation and rights safeguarded by the ECHR. The court deemed it inappropriate to declare the incompatibility without giving Parliament the opportunity to consider the matter. Lady Hale and Lord Kerr, however, would have issued a declaration of incompatibility, stating that the ban on assisting suicide without exception for autonomous decision is incompatible with Article 8. If the courts determine that Article 8 of the Convention requires voluntary active euthanasia to be a defense against charges of murder in specific situations in line with Section 6, Clause 1, the appropriate action will be recognized. Is there such a defense under the doctrine of necessity? At the end, the court had declined in altering the law on euthanasia, deferring the responsibility to Parliament due to the numerous circumstances that would ensue. Recognizing that a comprehensive transformation involving various aspects of the issue is necessary, Parliament, through legislation, is better equipped to enact such a change. With that, I'll pass the presentation to Ren Sing Long.
To conclude, the judges really make law. In accordance with William Blackstone's traditional declaratory theory, judges simply discover and declare the law that has always been in place. Other scholars have offered quite different perspectives. Critical theorists argue the idea of judicial precedent is only employed to justify the judge's judgment and that the court decisions are truly affected by social, political, and personal issues. Briefly believe that judges' personal background have an impact on their decisions. Although Warren acknowledges that the judge makes a political decision, he doesn't find a fundamental problem with this. William Blackstone, a legal commentator from the 18th century, introduced the declaratory theory of law, which holds that judges only discover and declare the law that have always been by using the rules of precedent, being were to determine law according to his private sentiment, nor according his own private judgment. The according to the law are custom of the land, no delegate to belongs a new law, but to maintain and expand the old one. He claims that when a bad decision is made, the subsequent one that reverses of our rules is neither a new law nor that it says that the old decision was bad law. Rather, it says that the previous decision was not law, or in other words, that it was the wrong answer. Furthermore, it's undeniable that the judges occasionally make laws. The appropriate time for courts to make law is up for dispute. Francis Burney has noted the risk that if the courts are so willing to make laws, they may weaken the position of Parliament. However, when judges make laws, they can adapt it to the changes in society as illustrated in landmark cases, such as Donoghue and Stevenson, and the case of Acknowledge and O'Brien. This case shows how judges has shaped the law over time by establishing new legal principles and adopting existing ones to reflect changes in society. There leads to be a balance between the roles of Parliament and the court, as the judiciary is getting readily involved in policy making. And many people think that policy should only be a matter for government and Parliament. Judges recognize this as seen with the euthanasia cases. The issue of judicial autonomy is a source of contention as far as lawmaking or law-making is concerned. However, because new empirical features are being included into the law, the judiciary's participation is beneficial for the creation of laws and result in our social benefits through improving the legal law and democracy. That's all from us. Thank you.